Forget New Year, New You. This season is about slowing down, locking the doors, and cozying up at home with the one you really want to do nothing with. Your dog. After the holiday chaos, those quiet nights with a blanket, a podcast, and your pup feel like the reset you actually need. Ollie helps make those moments easier with fresh protein-packed meals made from real human-grade ingredients, so your dog can enjoy some quality comfort food too. Choose from 5 recipes and get a personalized plan for your dog's needs. Meals arrive perfectly proportioned with a scoop and storage container, so serving is fast and mess-free. And with Ollie's in-app on-demand health screenings, supporting your dog is easy, ensuring more cuddles for many years to come. Visit ollie.com/truecrime and use code TRUECRIME for 60% off your first box.
Hi everyone, this is Jillian and you are listening to Court Junkie. Today's brief is about recalling the judge from the Brock Turner case. If you haven't yet listened to my last episode, episode 58, about Brock Turner, be sure to listen to that one first before continuing on with this one. So in that episode, I covered what happened in the case, how 19-year-old Stanford student Brock Turner was charged with the rape of 22-year-old Emily Doe, who was unconscious at the time. 2 graduate students were riding their bikes in the early morning hours on January 18, 2015, when they came across a man, who would later be identified as Brock, on top of an unconscious female, who would later come to be known as Emily Doe. They were on the ground, behind a dumpster, by the Kappa Alpha fraternity house on Stanford's campus. Brock was charged with 3 felony counts: assault with intent to commit rape of an intoxicated or unconscious person, sexual penetration of an intoxicated person, and sexual penetration of an unconscious person. He was convicted of all 3 felonies, and much to many people's surprise, he was sentenced to just 6 months in county jail, not prison, 3 years probation, and had to register as a sex offender. So after just 3 months in the county jail, he was released, and people were outraged at the lenient sentence. In the episode, you heard from Professor Michele Dauber, who spearheaded the movement to recall the judge in the case, Judge Aaron Persky. And in June 2018, the campaign proved to be successful. The voters decided to recall him. My conversation with Professor Dauber was extremely insightful and fascinating, and so I decided to dedicate this entire brief to her recall process and to get into more specifics about what went into the decision to lead the campaign. So, first things first, the history of the recall process in California.
The judicial recall was added to the California Constitution in 1911, which is the same set of ballot initiatives that added women's right to vote in California. So they got the right to vote 9 years before they did in the United States generally. And the motive for the judicial recall was the idea that judges were acting in accordance with special interests and were not responsive to the people. And it was something that labor wanted very badly after organized labor, or the effort to become organized labor, particularly after the decisions around the striking down labor legislation, and also striking down workers' compensation, and also allowing labor injunctions, that is, to block labor unions from organizing. And so the idea was, how are we going to keep judges accountable to the people they serve? We're going to give the people an opportunity to use the direct democracy process and, use the recall petition. And California, of course, is known for direct democracy, so it's not surprising that, we would adopt that into our Constitution. And it's also, there are several other states, including Wisconsin, other progressive states. This was a progressive reform at the turn of the century.
So how does the recall process work? Well, since we're talking about a recall that occurred in California, according to the California Constitution, the recall process allows people to recall and remove elected officials and justices of the state Supreme Court from office. Generally speaking, the process goes like this. You file and publish your notice of intention to recall, you collect a certain number of signatures for your recall petition, And if you get the required amount of signatures, and those signatures are verified, your recall then goes to an election, where it's then left up to the voters. In the recalled Judge Persky campaign's case, they collected nearly 100,000 signatures, which was significantly more than what was needed. So in June 2018, it indeed went to the voters. And this recall was very significant because although the recall process has been around for an extremely long time, only 4 judges in California had ever been recalled. Professor Dauber said that one of those cases, from 1913, was the precedent for the recalled Judge Persky campaign.
The first use of the recall in California, extremely interestingly, is related to women getting the franchise. And in 1913, just 2 years after it became part of our Constitution, there was a judge in San Francisco named Charles Weller who was recalled by the women's clubs of San Francisco for being lenient on rape. There was a serial rapist called the Golden Gate Rapist who was assaulting young women in Golden Gate Park, and a businessman, successful, privileged businessman named Albert Hendricks was arrested.
Despite the horrific crimes he was accused of, including the felony assaults of 17-year-old girls, Judge Weller gave Albert Hendricks an extremely low bail amount, and afterwards, Hendricks skipped town, leaving many to criticize the lenient treatment.
It was a very Brock Turner-y feeling situation, actually. And the women of San Francisco really rose up, and they collected, thousands of signatures with the help of labor and put it on the ballot and recalled Judge Weller and replaced him with a judge who was a progressive reformer, good government type. So that really was our precedent.
In episode 58, I talked a little bit about what made Professor Dauber decide to start the recall campaign. And one of the reasons has to do with what she says is Judge Persky's history of lenient sentences for defendants who are accused of some sort of violence against women. Professor Dauber and a team of law students started analyzing Judge Persky's prior cases, and she said they were pretty surprised at what they found.
We went into the courthouse and obtained his docket, which was itself another story because the clerks would not give us his record. I think that was, they were trying to protect him. I mean, that was appalling, actually. We had to fight to get his record. When we did get his docket, we looked at every single case, and we found, first of all, he was only a criminal court judge in Palo Alto for 18 months. So this was not like some long-time judge. That was just a fabrication. I mean, he had been a judge for 12 years, but he had only been a criminal court judge for 18 months. And while he was in civil court, of course, he did the Dianza case, so nothing to brag about there. And in the criminal courts, he had only handled 64 cases that involved any kind of violence against women. So it was quite infuriating that his campaign claimed, thousands of cases. At one point, someone said hundreds of thousands of cases. I mean, it's just like a ridiculous thing. There were 64 cases. And of those, we found, I think, a large number that, really were problematic, some of which were publicized and some of which were not, but were still quite problematic, involving domestic violence, sexual violence, and child pornography.
The Akeka Gunderson case, one of the cases I referenced in episode 58, is one of the cases they came across.
Mr. Gunderson's case is worse than the Turner case in many ways, although less sensational. Mr. Gunderson was also a college athlete like Mr. Turner and like Judge Persky and like the Dianza, athletes. So, there's a pattern. Mr. Gunderson was a football player at Foothill College. He was from a very Stanford-connected family. His mother went to Stanford and graduated around the same time as Judge Persky, and she was an executive at a tech company. His sister also went to Stanford and had graduated, very recently before his crime. And while he was at Foothill, so he wanted to play Division I football, and for some reason he, didn't quite make it. His father was a football coach, and so he came to Foothill College to maybe to hopefully transfer to Stanford, but to transfer to a school with a D1 team. And he had a girlfriend, and She broke up with him because she thought he was abusive, and then they went out to dinner to reconnect, and in the car after dinner, he beat her really savagely. I mean, he punched her. He's a really big guy. He's a linebacker. He benches like 300-plus pounds, and he beat her in the face with a closed fist and repeatedly, and then strangled her and then pushed her headfirst out of the car. And the police, were called, and she ended up at the hospital. And he ended up pleading no contest to felony domestic violence, which is a very serious charge in California. And it carries a potential prison sentence. But in between the time of his arrest and the time of his guilty plea, which was a few months later, he got some interest from the University of Hawaii football team. And Judge Persky allowed him to enter his guilty plea and then leave the state and go to Hawaii to play football. And that violates federal law. Once someone has entered a guilty plea, they are subject to something called the Interstate Compact for Adult Offender Supervision. You can't just let them leave the state. That is not a thing. You have to get permission from the receiving state, and the receiving state has to agree to supervise the individual. So you can't just let them go. And unsupervised, it's not safe. Well, so the district attorney actually raised that and said, I think we need to talk to probation about this deal because there are issues of an interstate compact here, and Judge Persky refused and let him leave the state. Predictably, with no supervision in Hawaii, Mr. Gunderson did not do anything he was supposed to. He had some very minor conditions. He was supposed to go to AA, and he was supposed to take a domestic violence batterers class. He tried to take the class online. That's also illegal in California. He didn't complete anything. He didn't stay in school, and he didn't stay on the football team. And he left the state of Hawaii and went to a different state, Washington, where he then was rearrested for domestic violence and eventually was brought back here and served a few months in jail. So that is another example, I think, of Judge Persky breaking the rules and bending over backwards in order to assist a college athlete who committed violence against women.
And in another case, Judge Persky sentenced Robert James Chain, a defendant convicted of child pornography, to 4 days in jail, which was not the norm.
We looked up the sentencing history of every other judge in the county with offenders who were similar to Mr. Chain, and we found that every other offender received 6 months for that crime. Now, we could have a conversation about whether we think 6 months is long enough or not. I mean, federal system, it would be years. Maybe that's too long. Somewhere between 6 months and somewhere between 4 days and 10 years is probably the right sentence, but it's not 4 days. And so in our county, that's a 6-month crime. Everyone acknowledged that, and no one really had a good explanation for why Judge Persky would give 4 days to anyone for that. There was another child porn defendant who didn't get written about in the paper because at this point the reporters were like, this is repetitive now. They no longer wanted to write about it. But we had another one, another white, so Mr. Chain was white, another white middle-class child porn felon who got no days in jail because he was building a vacation home in Yuba County. And the judge, listened to arguments that, this would mess up the construction schedule. And so attempted to allow him to transfer his probation up to Yuba County and not serve any jail time whatsoever. So, it was just very clear from reviewing his record that Judge Persky did not take violence against women seriously. And that is why we pursued the recall.
In addition to looking into Judge Persky's prior cases, Professor Dauber said she witnessed Judge Persky rule in another case that occurred during a break in the Brock-Turner sentencing.
Even, in fact, while we were sitting there in the courtroom, there was a break in the proceedings, and they, to allow the judge to handle some routine matters. And during that break, one of the routine matters was the sentencing of a domestic violence perpetrator. who was getting weekend jail. He was quite privileged. He was an engineer at Cisco Systems, and his victim was a much less privileged woman of color who actually was extremely angry and was there to object to the plea agreement, which she thought was too soft. And, she had been very severely beaten. She brought color photographs of herself. She was an immigrant, so she was really struggling with English. She was having a lot of trouble getting through her statement. And the judge treated her, I think, quite disrespectfully, and that was the sort of overall kind of consensus in the room. He kept interrupting her and basically asking her to sort of move it along, like we all know the result that we're getting to here, so, And every time he did that, she would get upset and have to start over. So it was like this painfully long situation that it felt like it went on, although it probably was, half an hour, because it was so painful, that she was saying, I feel that I'm being denied justice because I'm an immigrant. No one cares about immigrant women. But, he beat me severely. He pulled out handfuls of my hair. I mean, she had these photos. They looked like morgue photos. And The Guardian later did a big write-up about her story because the Guardian reporter was in court, to follow the Turner case, and was also shocked by what they saw. So we knew about that case, and I remember thinking, he doesn't seem to be interested in this case, and although it's different, it's similar, right? It's also violence against women. So I remember feeling like, this is a bad omen.
Despite being armed with Judge Persky's prior sentencing history, the campaign did face resistance. There seemed to be two arguments I found that were made against the recall, and I wanted to get Professor Dauber to respond to both. The first argument is that Judge Persky didn't break any laws when he handed down those sentences. Each time, he was within the law to do so. And the second argument was a little more complex. But many people argued that if we start recalling judges for their lenient sentences, won't that make the judges then give out harsher sentences for fear of retribution from the public?
The first one is, it was within the law. The judge has a range of discretion. And to say that what he did was not illegal is not to say that it was right. And it is precisely because he had discretion that it is appropriate to hold him accountable at the polls for the decision that he made. If he had no discretion, if the decision that he made was mandated by law, for example, that would be different. It would be unreasonable to hold him accountable for something he was required to do. It's precisely because he wasn't required to do it and he made the decision to do it based on an exercise of his discretion, using his own judgment, that it is completely appropriate for the voters to hold him accountable for that. That's exactly the role of the voters here. So didn't break the law is not a particularly persuasive argument for retaining any elected official. Vote for me, I didn't break the law. That seems like it's the floor and not the ceiling. And, it is his values and whether they reflect the community's values on this subject that really were at issue here. On your next question, that's a longer and harder question. So you're asking, I think, is the recall a good idea because will it send the wrong message to judges? The message of this recall is that we cannot treat rape or serious sexual assault, felony sex crimes like misdemeanors, like shoplifting. This is a judge with a pattern of bias, and the message of the recall is bias is unacceptable. So I don't believe that it is credible or plausible, given especially the massive amount of media coverage of this recall, that any judges are confused in any way about what the message of this recall is. I don't believe there is any judge out there who thinks that the message of this recall is you should sentence every criminal defendant to come before you more harshly. I think that this was about Mr. Turner, and this was about giving privileged felony sex offenders and privileged felony domestic violence perpetrators incredibly and unreasonably light treatment and the disrespect that shows to women.
And the main thing the recall campaign was trying to do was to give the choice to the voters.
I have always believed, and our campaign has always believed, that the venue for resolving these concerns with Judge Persky was the voters, the ballot box. That these are questions that you take to the voters. And it is the job under California law of the electorate to hold elected officials accountable. And, his campaign, I think, the legal profession, as I said before, really rallied around him, and they raised this issue of, quote, judicial independence. But there is no such thing as an elected official who is independent of the electorate. Judge Persky is elected, period. And that is why the appropriate venue for resolving the concerns of women was always with the voters.
The resistance largely came from the legal community and from Judge Persky and his supporters. They formed an opposing campaign called Reject the Recall. Their tagline was, "Don't recall a respected judge who followed the law."
Throughout the campaign, there was just a persistent unwillingness of many lawyers, not all lawyers, because we have many lawyers supporting our campaign, but many lawyers and certainly other judges who reacted to the recall with, what I would call, hysterical pearl clutching, saying, all manner of slippery slope fallacies, I think one of which you already asked me about, won't everyone go to jail forever if Brock Turner has to, be accountable? All judicial independence will end, and this will be the death of, the whole idea of a fair and independent judiciary. I mean, it was just like, just a ridiculous parade of horribles. And really no response to the question of, why are women so upset about the handling of sexual assault and sexual harassment in the legal system, right? There just was a very, very big blind spot there. And what I hope will happen now that we've won is that moment of introspection can happen, and that they can say, well, not only it won by a massive landslide of almost 30 points, so maybe there is something there for the legal profession to look at. And one of the most persistently frustrating things to me was that, there was a kind of an Ivy League almost preciousness to many of the reporters, not all, but many, who covered this story from the national press. And they kept wanting to portray this as, a split in the progressive movement, criminal justice reform advocates on one side and women on the other. That's just false. Here's what we had. We had everyone on one side except the legal profession, and the legal profession on the other side.
I alluded to this next part in the episode, but didn't want to get too much into it then. But Professor Dauber actually received numerous death threats for her involvement in the campaign.
During the course of the campaign, I received a lot of angry, misogynistic hate mail, actually. And I had a tendency to, when I received it, take a picture of it and tweet it, because I think that people who are bullies and harassers, are counting on silence, and that it was important to show to the world, that this is what happens when women stand up. And I think we sort of know that from Twitter trolls and things like that, but anyway, that was my perspective. I'm going to post this. And so I would tape it to my office door and tweet it. And anyway, so I got one of the many dozens or hundreds of, angry, hateful, semi-threatening things that I received, was a threatening letter that had glitter in it. So when you open it, it sprays glitter everywhere. And it was from some company called Ship Your Enemies Glitter or something. And anyway, so I thought that was kind of creative, and I tweeted it. And then about shortly thereafter, maybe a couple weeks later, I received a card that had the same words inside, but also had white powder in it. And that, of course, is the thing you're referring to, and it caused the shutdown of the university. And it turned out, or part of the university, and it turned out that the individual who sent that had sent me, the same individual had sent me the glitter bomb. It was the same words, and I recognized it. And the FBI was able to figure out who the individual was, and this was an individual who had sent, allegedly sent threatening letters and white powder letters to many people. And so it looks as though today this individual has agreed just now to plead guilty in connection with that crime and the others. So that was a, extreme case. But there were other cases. There was another individual who sent me threats and actually came to my house here in Santa Clara County, and that individual also was sentenced to jail for threatening me, as well as some others. Individuals, and in that case too, misogyny seemed to play a role, as it did in the white powder letter case. So I think that when women stand up publicly on behalf of victims of sexual violence, they can expect to get backlash, and in some cases, that backlash can include threats of violence.
So what's next for Professor Dauber, now that the successful recall campaign is over?
Well, what we're doing now is we're transitioning to a project that is very focused on holding elected officials accountable when they don't take sexual assault seriously, and making sure that violence against women is a voting issue. I think that our key takeaway from the last 2 years is that we have to take the legitimate anger of women about, the Me Too set of issues and translate it into actionable, effective electoral behavior. Because the system is really engineered to ignore the complaints of women, but what they can't ignore is when you vote them out of office. Like, that's just, that's a very definitive outcome. And we have to get people voting on this issue and using their power at the polls in order to send this message. And, I think over the last 50 years, a lot of different things have been tried on the subject of sexual violence. We've tried, asking nicely. We've tried lobbying. We've tried passing laws. We've tried setting up nonprofits. We've tried, making documentary films and trying to clear the rape kit backlog. And why don't we just try voting? That's my belief. This is a democracy. Voting settles the issue. And so if we can, essentially continue to do what we did, which is put rape culture on the ballot and then vote it down, eventually that will work. And I think that that is where my effort and energy is going to be going. And to that end, we have the same team that did the recall has launched a political action committee called Enough is Enough. And we are actively looking at elections around the country and targeting individuals, particularly state legislators, who are credibly accused of sexual misconduct, sexual harassment, sexual assault, child sexual abuse in one case, and targeting them to, expose their record, educate the public about, and work for their defeat.
And that's all for today's Court Junkie Brief. A special thank you to Professor Dauber for speaking with me about the Brock-Turner case and about the recall campaign. You can follow Professor Dauber on Twitter at @MLDauber, and also follow their ongoing efforts to put violence against women on the ballots on Twitter at EnoughVoter. Their website should be up shortly, so be on the lookout for that at enoughisenoughvoter.org. I'll also include these links in the show notes. As always, you can find me on Twitter at CourtJunkiePod, on Instagram at CourtJunkie, or you can email me at podcast@courtjunkie.com. Thanks again for listening. Until next time.